objectively reasonable, they have to first concede that a seizure occurred. So that's almost the entire answer they give in the appellate brief to this question, and they agree with us. But even then, as we note in our reply brief, these two questions, one of statutory justification and two of constitutional protections, are ones that this court cannot answer without abridging the principles of appellate process. So ultimately, both questions that the appellate brings up in his merits brief don't really apply to this case and cannot be determined by this court. And this court has almost universally neglected to answer those types of questions or entertain those types of arguments in previous cases. So, with that being said, I want to quickly go over why exactly we're entitled to reversal. If you review the lower court's opinion, you see that they ultimately determined that we lacked legal basis to proceed with this case on the sole reason that no seizure occurred under the Fourth Amendment. And for that reason, there was no deprivation of rights. So ultimately, we lacked legal basis. That was the only definition or determination that the court used in order to dismiss this case. So ultimately, just a mere finding that a seizure had occurred under the Fourth Amendment and that lethal force is entitled to a Fourth Amendment, that lethal force is a seizure under the Fourth Amendment would allow this court to reverse the lower court's opinion and remand it for further proceedings under the opinion. Does the court have any further questions?
Where do
You
you...
with no one
Oh,
else.
sorry. You could go ahead.
Hi, Justice Danny.
Hello, counselor. Have you by chance read or at least skimmed the recent Supreme Court ruling in? Hold on. Torres v. Madrid.
I'm not familiar with that case.
All right. Well, the holding of it is particularly relevant of this case, so I was going to ask a question, but there's no point in asking you about something you don't know about, so I will cease.
Okay. If you'd like to inform me of the holding, I'm sure I can maybe answer your question still.
Well, that would be almost handing you this case, counselor, and I don't think that's very ethical.
Okay, fair enough. Mr. Chief Justice, did you have a question?
We're specifically in Mr. Nomadity's decision in the lower court's decision, I guess, rather, do you find that the decision falls short in
So oh, sorry, go ahead.
holding to the provisions of the seizure, or more specifically, just in general, your questions asked of this court?
Right. So in the lower court's holding, let me actually pull it up really quick so I can reference specifically. The lower court literally specifically said that a seizure hadn't occurred under the Fourth Amendment because they established this two-pronged test that is necessary for a seizure to occur. They
And
basically
do you
first
agree with this two-pronged test?
I don't agree with the two-pronged test, and the Supreme Court of the United States doesn't either. In fact, they've said in multiple cases, like Mindell v. United States and California v. Hidari, that the two-pronged test is actually used with the conjunction or as opposed to and. So it requires a submission to a submission to the authority of the officer or the use of physical force. And ultimately, the lower court says and that's simply not the correct analysis under the Fourth Amendment, because that's what the Supreme Court has basically analyzed the antithesis of that. So that's why I would reject the analysis in the two-pronged test.
I think the first prong of his test was that there must be a show of authority of a police officer. Do you think that a person in the person in this lower court's or in the lower court's decision had been seized to a show of authority?
I guess it would depend on how you classify a show of authority. I wouldn't argue necessarily that a police officer must make it known that he is a police officer in order for a seizure to necessarily occur. I would argue that seizures are rather objective. The determination as to whether a seizure occurred is rather objective, not based on the perspective or reasonableness of how an individual would perceive at the time of the seizure. So, and also, I don't even think that this case would fall under the first prong because it falls under a physical force. And the Supreme Court has made the distinction between the show of authority and the use of physical force. So they either have to submit to a show of authority or there must be the use of physical force, which restrains liberty, which is ultimately the prong that this case falls under.
Thank you. I don't know if any other justices have questions.
If there are no further questions, the appellant would urge reversal to the fullest extent, and we yield our remaining time to the court.
Thank you, Counselor. Travis?
Hello. So, Mr. Chief Justice, and may it please the court, I am Travis Kabab, the Solicitor General and the Counsel of Record for the Appellees Party. While the Supreme Court of the United States has ruled and held that lethal force is a form of a seizure, the state believes that it would now be appropriate to adjust those standards to a more abstract application and understanding of this notion. In my two briefs I supplied to the court, I did mention and include relevant statutes, doctrines, and principles for the court to keep in mind while deciding this case. The question before the court is whether the district court erred in holding that the use of lethal force by a law enforcement officer did not constitute a seizure under the Fourth Amendment of the United States Constitution. The lower court echoed two prongs that the United States Supreme Court created in their holdings in a few cases. To remind the court, the first prong is that there must be a show of, or quote, there must be a show of authority by the police officer, end quote. This is a requirement that is actually held in Terry v. Ohio, to which I'd like to provide the court with the exact wording of the court's language, and I do include that language in the last sentence of page 3, where it does continue on into page 4 in my response to the appellant merits brief. For argument's sake, I will include that statement orally to you all, rather than having you all find it yourself. The court stated that a seizure occurs, quote, only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. Now, I think that in all that there was no physical force, rather than we are looking at full force, which we all know to be synonymous with one another. Of course, lethal or deadly force is what's synonymous. While the lower court may not have cited that requirement in Terry v. Ohio, that does not mean that their holding is incorrect. Linguistically and legally, that prong is the requirement that the Supreme Court did design in Terry. Following that, the second prong is, quote, the person must, or, quote, the person being seized must submit to the authority. Terry v. Ohio was decided in 1968. The language of the second prong is relatively the same language of the requirement that was established in California v. Adari D, which was decided in 1991. Clearly, over the years, the requirement of what defines a seizure has shrunk in terms of a word count. However, it is the belief of the state that because a submission to the authority did not occur, we do not see how one could call this a seizure or even categorize it as a seizure. The defense of the phrase submission to authority would be the same as saying someone succumbing to another person or perhaps persons who has more, for lack of a better term, power in a situation. To provide an example to the court, when an individual is pulled over on the side of the road and the officer requests for the driver's license and registration of the driver, that would be a submission of authority as you are complying with their orders and or requests. In my reply to the appellant's merits brief, I included the notion of stare decisis, and that I feel that the court would be in the boundaries of upholding the content within that particular doctrine if the court were to enforce what the requirements of what a seizure is. Then that would be an example of the court upholding the doctrine of stare decisis. Therefore, the lower court did interpret the Fourth Amendment of the United States Constitution accordingly and pursuant to the case law prescribed by the United States Supreme Court. Um, I include in my merits brief particular statutes that the court should also keep in mind that define and sort of detail uh, instances and exceptions regarding lethal force. Of course, that is all contained within the Law Enforcement Lethal Force Act of 2020. I provide a handful of statutes and provisions in that particular act that describe in detail when one may engage in lethal force as well as when one is not protected under those statutes due to their acts going too far in this concept. Um, it is mentioned that the prongs established in the lower court's decision have a conjunction error that conflicts with the Supreme Court's holding in a few cases. As I reread the lower court's holding, I do not see that conjunction error, unless I'm reading the wrong thing, but I do not see this conjunction error. In fact, I see them echoing, as I said before, the Supreme Court's holdings in California via D, as well as Terry v. Ohio. While they may not have cited those cases, those prongs certainly still apply. It was really fairly recent, it was in this year, that they held the application of physical
Counselor, I
force.
have a question for you.
Yes, of course.
Do you agree in the finding of the lower court that there was a sufficient show of authority by the police officer?
I do, because if you review the evidence that was submitted to the lower court, the police officer is present in the video at the timestamp of, let me get the exact minute and second. I will say that he does have his sirens on, and you can also hear those, and you do see him drive by the appellee in the video. You see him drive by at the timestamp of 1 minute and 6 seconds.
Now,
And
now with the show of authority, how do you contend that there was not a sufficient submission to that authority?
a submission to authority and a show of authority, I would argue, are different,
Well, I agree
conceptually.
that they're different, but um, I guess my question is more specifically, why do we agree that there is a presence of authority or a show of authority? How so is it that when the show of authority by the police officer kills a person, is that not a um how is that not a
Restraint.
restraint?
I'm
Or
not sure if I understand your question.
how when that officer who we've recognized as a show of authority, when they restrain someone through killing them, how is that not a submission to authority?
I will point out that in the evidence submitted to the lower court, that if you go to the timestamp of, let me get the exact minute and second. 1 minute and 20 seconds, you do see that the suspect that the officer is trying to detain, as he has handcuffed him, but now this individual has run away and is now riding the hood of the appellee's vehicle. As they reach the uphill of the road, the officer, the appellee, is now firing his weapon uphill at quite a physical distance, to the point where he's almost blurred out of the video. One could only assume from his perspective that he is having trouble firing his weapon to the individual he is trying to detain, who has also run away. With a restraint of liberty, I do not see that that is applicable here, simply because of a, I suppose, tactical error in firing his weapon, as he is now at a physical distance, and the vehicle is going uphill, where the suspect he is trying to detain is also being covered with the roof of the vehicle. So now the suspect has cover as well as geographic, where he has a geographic advantage to the officer. So I do not see that there is any malicious restraint of liberty, nor do I see that there is a non-malicious restraint of liberty in this case as well.
Might I interject, Justice Bleed, and continue on with what I think you're trying to say? Okay, I guess I will then.
I don't know
Counsel,
if Justice Bleed was talking.
well, we are not here to debate the legality of this shooting. We are here to debate if it is a seizure, whether or not it is a lawful one or not. And what I believe Justice Bleed is attempting to ask is, how is the state killing someone? One of its most extreme exercises of state authority, in this case a police power, intentionally or not restraining them from the liberties guaranteed to them by the US Constitution.
I do not believe that the law enforcement officer was attempting to restrain the liberties of the appellee, rather the liberties of the suspect he is trying to detain.
Okay, then.
Can you repeat that for me, please?
I think I said almost verbatim that the law enforcement officer is not trying to restrain the liberties of the appellee, rather, he is trying to restrain the liberties of the suspect that he is pursuing, who is also the vehicle, or I'm sorry, the individual on top of the vehicle, the appellee's vehicle.
Thank you.
Does that make his seizure justified?
I would argue that a seizure did not even occur to the appellee, as he was not engaging in lethal force to the appellee rather than lethal force to the suspect he was trying to detain.
So because he, I'm just trying to walk me through what you walk myself through what you're arguing. Because he was shooting at and he killed the person who was not restrained, it was not a seizure.
Yes, correct. It was not a seizure of the appellee, rather it was an attempted seizure to detain, or rather seize, the suspect he was originally going after.
All right. And I'm gonna ask you what I define, or what I asked Clifford. How do you define a seizure?
As I said in my opening statement, the Supreme Court has defined a seizure as, let me get the exact language. Um, a seizure occurs only, well, no, that's a particular scenario. I want the exact language. I cannot seem to find the exact language, though I do know that the case of California versus Hadari D did define what a seizure is. However, I'm having trouble um finding it within my arguments. A seizure requires either physical force or a submission to the assertion of authority. To which, then, if those are satisfied, then yes, you have a seizure. But since we, I hope, can all agree that there was no physical force, rather lethal or deadly force, that particular clause is not what's applicable here, but rather the latter of a submission to the assertion of authority.
All right, I'm just gonna wrap my head around this one more time. So your argument is that because the officer shot at a person and killed a person who was not already in handcuffs or not physically restrained, there was no seizure.
Correct.
Okay. I do not have any further questions at this moment. Frost or Sophie?
One second. Okay. We're still a little confused about the portion of your argument where you're saying that. So because just give me a second.
We're being murdered. If you will give us a minute here.
Yeah, but okay, sorry. So basically, in short, you're arguing that because the appellant was not restrained, it's not a seizure, even though he was killed by the law enforcement officer, correct?
Wrongfully killed by the law enforcement officer, as he was not the intended target of the law enforcement officer's shooting. To which then that would extend into the to an unaccessible seizure, in short.
Okay. I'm going to read you something. So in Broward versus County of Inyo, not saying that right probably, in 1989, it's read that it is clear, in other words, that a Fourth Amendment seizure occurs only when there is governmental termination of freedom of movement through means intentionally applied. In this context, although the appellant was not the intended suspect, how do you still think it was a seizure? Not a seizure, even though that the actions to use lethal force were intentionally applied.
Could you read the clause of the intention part one more time? I want to put the word intended in its context. Well, what's the direct object of intended? What's the word that comes after it?
Let me get it again. It says, it is clear, in other words, that a Fourth Amendment seizure occurs only when there is a governmental termination of freedom of movement through means intentionally applied.
Through means intentionally applied, while it was intentionally applied to fire his weapon at the suspect, I would argue that that particular statement would not imply entirely in here, while it is important to remember that, it would not be applicable to this case simply due to the fact that those intended means did not reach or meet the intended target.
Okay, wait. So, hold on 1 second. I have a question for you. So, when you submitted your plea of demur, or however you say it, I'm actually not too sure how to pronounce that word. You're accepting the facts pleaded in the complaint, right? That was actually somewhat of a rhetorical question, because it's basically yes. That's what a plea of demur is. Are you aware of what the complaint says with regards to who or what the officer was shooting at?
I would have to look at the complaint again.
Well, let
For-
me pull
for
it up
the
for you for
exact-
1 second. Let me just quote it for you. So one of the allegations is, let me just see real quick. Once the
I also have
plaintiff,
it pulled it up.
hold on, it's clause number 7. Once the plaintiff was roughly 3/4 up the road, the plaintiff directed his attention away from the police crusader and began firing at the defendant until he eventually killed him. So you're conceding, basically, that the officer was in fact shooting at the appellant. Do you have any response to that?
I think the prepositional phrase of "at the defendant" is incorrect, as it would be in that direction, but not at the defendant.
But hold on. You submitted a plea of demur, though. You're accepting the facts stated in the complaint as true.
I don't feel it's necessarily what we argued in that plea, however.
Well,
Even though
that's
would
that was the plea you submitted. There is a distinction between that plea and a motion to dismiss.
Our plea, however, its intention was to, by extension, dismiss the case due to the fact that the plaintiff cited a U.S. code as its tort rather than the notion of depriving one of his rights.
Okay, let's say I'm just gonna, for the sake of argument, I'm going to assume, for example, it's not, but I'll assume it was a motion to dismiss. All right. So we're gonna ignore the fact that you accept the facts as true. The decision by the lower court was to basically dismiss the case without hearing, like having a hearing basically first. So in these circumstances, we have some guidance on how we're supposed to treat motions to dismiss. We're supposed to accept the allegations made by the plaintiff as true, and we're supposed to view them in the most positive light to the defendant, or sorry, rather the plaintiff's case. So in that situation, I'm confused about how you can bring up the fact that, or rather the theory that the police officer is not actually shooting at the appellant. Do you have any response to that?
I still have to uphold my argument of it was the incorrect preposition to use in the complaint, as it was not at the defendant.
But you can't.
Rather,
The problem is you can't be pleading facts right now, right?
I can or can't be. I'm not sure what you said just now.
You can't be, because it was in effect a motion to dismiss. It's not actually a motion to dismiss. It's actually a plea of demur, which actually harms your case more. But for the sake of argument, we'll say it's a motion to dismiss.
Typically, the definition of this plea is that you accept the legal arguments as true, but due to some circumstances, you have to engage in this route.
Sorry, could you
Whether
repeat
or
that?
not, sorry.
Could you repeat what you just said? Sorry, I didn't catch that part.
Typically, the definition of this type of plea is that you accept the legal basis or the arguments and situation is true, but due to some, I guess, third-party circumstance, you have to go this way. And in this case, it was the fact that the plaintiff argued or submitted the case with their tort as a code within the U.S. code, the United States code. Due to that, there would be no way to. We felt in my office that there was no way to dismiss the case on that basis, but rather instead to go this way.
I mean, to add on to Frostfleet's point, where I guess to continue, the plea of demur does, reading it right now, it does say, after being fired upon, plaintiff swerves into the opposite road. So it not just does the plea of demur, you know, say that we're accepting facts, but in the plea of demur itself, the plaintiff, in this case, Amit, is conceding that he was shot at.
He was shot at before the officer was shooting at the vehicle, because if you look in the video, he's already at a low percentage of health as he is riding the appellee's vehicle. So at some point, the appellee did shoot the suspect, but he did not shoot the. Well, no. Let me make sure my character is correct. The appellee, towards the end of the video, yes, shot and killed the appellant. However, in this case, in the lower court's case, the fact that the appellee's gun was being fired at all is not because of the appellant's actions, but rather of another individual's actions. And he was a tourist who I'm not sure what he was.
Hold on. Where are these facts coming from?
The video that was submitted.
But we're
to
not
the-
here to find facts, are we? We're only here to discuss what was it like. The only facts that we have to go off right now are the allegations made in the complaint. That's all we have to go off of right now. We're not finding facts right now. We can't be looking at what was going on in the video.
Yes. However, in the video, it's important to note if a seizure occurred at all pursuant
No.
to the
No.
court's
No,
definition
hold
of
on.
what a seizure is.
We're looking at the allegations from the plaintiff, those alone, and we have to determine whether or not there is a cause of action there. Your contention, or what I assume to be your main contention, is that because the police officer was not actually shooting at or intended to shoot at the appellant, there was no seizure, right? Am I right? You can correct me if I'm wrong.
Because the law enforcement officer did not intend to shoot the appellee, there was no seizure.
Okay, perfect. I have to stop you right there because it is alleged in the complaint that the police officer did in fact shoot at the appellant. So that's what we have to go off of.
Which I am arguing is incorrect.
You can't. Well, we're not here to find facts.
Right. However, I am, for the record, stating that.
Do you have any other basis for why you feel this wasn't a seizure? Let me ask you a hypothetical then. I know you don't accept this, but let's assume for the purpose of argument that, for example, the police officer was in fact attempting to and did shoot the appellant. Okay, for the sake of argument. In that situation, would you be willing to concede that that was a seizure?
Because the Supreme Court has said that lethal force is a seizure, yes.
Okay, perfect. Thank you. I have no further questions.
Do you want to make any final remarks? You have 30 seconds left.
However,
Unless Justice Falk, any other justices have any questions. Alright, you could make your final remarks.
However, because the Supreme Court has said that lethal force is a seizure, then now would be the time to see if this court needs to take that understanding and perhaps adjust it, as I said, in my opening statement to fit more complicated scenarios such as this one. That is all.
Alright.
Thank you.
Thank you. Time is up. That concludes our oral arguments in 0511. Case is officially submitted. And the Supreme Court will then proceed with oral or discussion in chambers, and we'll have an opinion out as soon as we can, preferably by the end of next week. So we'll keep you all posted. Thanks for tuning in for the first ever voice session oral argument. Adios. If you're a justice, you should stay behind though so we can talk about it. Everyone else is gonna get kicked out.